We'll now begin the presentation on wills and estate planning with Irama Valdes. Irama Valdes is an attorney licensed in the state of Florida who navigates the complexities of estate planning, probate, and guardianship administration in litigation cases with compassion and a keen eye for details. Ms. Valdes is dedicated to aiding people with their incapacitation and end-of-life planning. She serves on several boards, including the Probate and Guardianship Committee, the Dade County Bar Association, and the South Florida Guardianship Association, which assists individuals in dealing with death and incapacity. Ms. Valdes and her staff have passion for assisting clients through difficult times in caring and efficient manner. I'd like to thank Irama for taking time out of her schedule today. And now, Irama, I'll turn the presentation over to you.
Thank you so much, Jackie. Can you hear me well?
I can.
All right, so let's see. Am I able to click?
Yay!
So hello, everybody. I am Irama Valdes. I am pretty much everything Jackie said. I am an attorney with the state of Florida, and I only practice in the areas of probate, guardianship, and estate planning. Most of what I love about having webinars is the education aspect. And I think that most people, when they don't know something, it makes it a little bit harder to deal with. So thank you all for joining me either today or in the future when you're watching this recording. I hope you learned something today. And if you have any questions and you weren't able to join us live, please feel free to reach out to me. I'm sure I put my contact information somewhere on this slide. So how to protect your family and your assets in the event of incapacity or death. And that little line back down there, what you don't know could cost you thousands, it's absolutely accurate. So let's start. All right. So I kind of started this webinar, or at least the idea for it, about 2 years ago when I was having a girlfriend play date. There was wine involved, which, you know, please grab a glass because you'll need it. We talk about serious stuff, but we want to make sure that, you know, it's light because of everything that's going on right now. But anyways, I was talking to my friends and they kept asking me questions about estate planning. I'm like, you know, I want to know why is it that people don't create estate plans, or what stops someone from taking that first step. And I came up with a list of reasons, and maybe some of these apply to you, maybe they don't. But you know, some people think estate planning is for rich people. It's not actually. And the least amount of assets that you have, you know, a lot of that could go to attorney's fees if you don't have the right estate plan. I don't have any assets, so is it worth it? Yes. And today you will learn why it's worth it. I don't want to think of those negative things. I know, trust me, I know. But sometimes dealing with these negative things could prevent more negative things from actually happening. So sometimes you got to deal with an issue right, you know, from the beginning, and you can avoid additional issues and maybe even attorney's fees at the end. I don't have money to pay a lawyer. It's not as expensive as you think, and we'll get into that later. I have my wishes written down on a napkin somewhere. This was a legitimate reason that someone on my Facebook told me that will probably not be enough. So make sure that, you know, whatever documents you prepare are legally, you know, well drafted documents, preferably by a lawyer, please. You know, I don't know what state you're in, but here in Florida, that's probably not going to fly. My spouse knows my wishes. There are so many wrong things that can happen just because of, you know, your spouse knowing. Doesn't prevent certain cases from happening. What if you and your spouse break up? Not that I want that for anybody, but, you know, we don't know. I don't have time for that. One of the things that we go into towards the end of this presentation are the steps that estate planning, that people that are on their estate planning journey take. And really most of the work is on me as the attorney that's drafting the documents. So the time commitment that's involved is minimal on your part. My spouse and I cannot agree on what we want for our kids. That's another issue we'll discuss. Simple neglect on my part, and my mom is on my account and she has access to my money. None of these are valid reasons, although they may seem like valid reasons at the time. But once we get through this, you'll see it's not that difficult, and it's something that everyone should really do. So here are some statistics so that you don't feel so bad. 74% of Americans believe estate planning to be a confusing topic, and it is. I completely agree that it is, which is why I have these webinars to educate everyone. But you're not alone. Americans who die without a will or an estate plan, 55%. Americans who say having a well thought out estate plan would help them feel like a good spouse or parent, 71%. So the desire to do this is there. And then Americans who earn more than $150,000 who have an up-to-date will is only 15%. So you're not alone, I promise you, but watching this webinar is definitely the good first step. So what can we expect from this webinar right now? Well, we're going to learn about 3 different things. The first thing we're going to learn about is probate. The second thing we're going to learn about is guardianship. And then lastly, we're going to learn about estate planning. And the reason I go over probate and guardianship is it will become more apparent in the future, but you know, you have to know the kind of trouble you can get into so that you know maybe how to not get into that amount of trouble. So the first, let's call it trouble, is probate. So probate is the process by which the court changes title to property and oversees the administration of your assets and debts after death. So in simple terms, that means that if you pass away and you have a house or you have a bank account and it's in your name alone, you're going to need a probate case to transfer those assets from your name as the deceased person to your beneficiaries' names. So when you pass away, whoever is your beneficiary or you know, a relative is going to have to open up a probate case to let the world know, hey, this person passed away, here are the assets. And a lot of clients ask me, what if we create a will? Well, a will does 2 things. It says who's in charge and who the assets are going to go to, but it doesn't necessarily mean that you have to avoid opening a case. So when you open a case, we have to go through a few steps, right? The first is appointing the PR. Of course, that's an acronym. It's a personal representative. In some states, it's known as an executor or administrator, but they all mean the same thing. It's, in essence, it's the person that's in charge of managing all of these assets until such time that they're distributed and creating that distribution for the person's beneficiaries. So the next thing that we have to do is marshal and liquidate assets. That means if there's real property, selling the property. If there are stocks, liquidating the stocks, cashing in on bonds, bringing in the checking accounts, money market savings, all of that into the estate. The next thing we have to do is pay debts and settle litigation. So sometimes when we have a probate estate, there are creditor claims that are filed in the estates, and you have to deal with those. If there was a mortgage on the property, that has to be dealt with as well. And if a creditor files a lawsuit against the estate, then that's something that needs to be resolved before any distribution can be made. And another type of litigation is, you know, perhaps maybe the mortgage wasn't paid and now the mortgage company is foreclosing. That's a separate case that gets started against the estate that has to be resolved before a distribution can be made. And lastly, if there was a wrongful death, or maybe the person passed away in a nursing home and there was some sort of negligence, the personal representative is the right person here in Florida anyways to be able to sue on behalf of the person who passed away for those wrongdoings. And before a distribution can be made, that litigation needs to be either settled or there needs to be a trial and needs to be put to rest before anything else can happen. So the last thing that needs to happen is the distribution of assets. And of course, if there are any beneficiaries that are not okay with, let's say, a will or the distribution that the statutes in the state that you're in say that you need to have, then you have to figure out a way to distribute the assets where everyone is okay, or have it set for hearing. So this is obviously not a very easy process. It can take quite some time here in Florida. For an administration, it could take a year, sometimes maybe more. The longest estate that I've been a part of, and I was a part of at the end, was actually 19 years it was open. And obviously it was a lot of acrimony between the families, and that's why it took so long. That's not normal, but about a year or two, that's pretty normal. So how many of you don't have a plan? And obviously I can't I can't see a raise of hands right now, but I bet you most of you watching this are going to say me. I don't have a plan. And I'm sorry to tell you, but you're wrong. So here's your plan. And here in Florida, we have statutes. And there are statutes that determine exactly what your rights are. And obviously, I'm not going to go over the statutes because we don't need to do that right now, but there are a lot of laws that say what happened when you pass away. What if there are stepchildren? What if there are half siblings? What about if you're married? What if there are adopted individuals or people born out of wedlock? If you've disinherited your spouse, all of these things come to play, and the law of the state of Florida and whatever state it is that you're in get to determine who is in charge and who gets your assets when you pass away. So that is probate in a nutshell. The next thing I want to talk about is guardianship. So before we do that, I'm going to take a sip. This is will and wine after all. So guardianship. Guardianship is a process where the court appoints one person to make decisions for another person because that person is incapacitated. Now, there are two different types of guardianship. The first is a guardianship for an incapacitated adult. Think of this as someone who's 18 or older, and I believe in some states it's actually called a conservatorship, but here in Florida it's called a guardianship. So an incapacitated adult is someone who's 18 or over that can't make decisions for themselves, whether because of a mental illness or a physical disability. So it could be someone with special needs or autism, or someone who's in a coma because of an accident, or someone who has dementia, bipolar, schizophrenia, anything that really renders that person incapable of making decisions for themselves, whether maybe a little bit of incapacity or a lot or completely incapacitated, a guardianship may be necessary. And the next kind of guardianship is a guardianship for a minor child. Usually I see this when one or both parents have passed away and someone needs to be appointed to manage either that child's funds, you know, if maybe there was life insurance that was left to the child, which is a big no-no, but we'll get into that. Or if both parents were passed away, then they need to appoint someone to take care of that child until that child becomes 18 years old. So how is it that we have guardianship established? For purposes of this webinar, I'm going to concentrate on the incapacitated adult because that one's the one that is a little bit more complicated. So the first thing you have to do is determine that the fact that they are incapacitated. You can't appoint someone to make decisions for someone else if that person doesn't have an incapacity. So you have to open up a mental health case to determine that they are incapacitated. And here in Florida, we appoint 3 doctors to go visit the person who's allegedly incapacitated to make a determination. And sometimes that person is incapacitated and sometimes they aren't. And then that becomes a litigation case all on its own. So the next thing is we have that incapacity hearing. So after those 3 doctors go and visit the alleged incapacitated person, then they file reports, and then the court hears those reports and sometimes hears the testimony of the doctors to determine whether they're incapacitated or not. And then we appoint a guardian. So who's appointed to make decisions? Usually it's a family member, a relative, a friend, someone who has their best interest in mind. Many times, you know, more than one person wants to be the guardian, and there's litigation between family members when they can't decide who it is. When that happens, that's when the judge steps in and makes the decision for you. Now, here in Florida, we have a statute that gives some guidance to the court as to who should be the person's guardian. So here, as you can see, any resident of the state who is 18 years or older. And here is considerations and appointment of guardian. So this is something that the court has to consider to be able to appoint the right guardian. And something that I want to point out is that the court may appoint any person who is fit and proper, whether related to the ward or not. So here in Florida, you don't have to be related to the ward to actually be the person's guardian, which is really scary, because what if, you know, you have a stranger that says, I'm this person's friend and I'm the one taking care of them, and all they really want to do is maybe control that person or their assets. So to me, that's the scariest part of a guardianship, is making sure that the right person is appointed, and the court has to follow the statutes of the state of Florida or whatever state you're in. So what happens after the appointment? the guardianship is in place until that person's incapacity goes away. Now, with a minor, obviously the incapacity goes away when that minor turns 18. But with an adult incapacitated person, it goes away when that person's incapacity goes away. And sometimes that incapacity doesn't go away, especially if it's a disease that has no cure, like dementia. If a person has special needs, as of right now, they're going to have special needs for the rest of their life. So that guardianship is going to last until they pass away. And annual requirements. So every year you have to let the court know two things. What is going to happen with the person's body, where they live, what medication they take, what doctors they see, what they're going to do for hurricanes, anything that has to deal with that person's body, you have to let the court know. And that's filed in the form of an annual plan. And you have to take them to the doctor. They have to get a checkup every year. And the second thing you have to inform the court is about the money. What money has come in, what money has come out, what expenses have been paid, what attorney's fees have been paid. All of that is known as an accounting. So that has to happen every single year. And it can be pretty expensive, but it's something that the court requires to make sure that the ward, who is the person that's under the guardianship, is being taken care of and that their assets are not being dissipated. So I want to go over a story. I learn much better by example. So this is a crazy story. It's a true story, which I think makes it all the more sad. But it is, you know, it has a little bit of everything. It has a little bit of probate, it has a little bit of guardianship, and at some point we're going to get into some estate planning. So there was a family. It was a mom, a dad, and 3 children, a 16-year-old, a 12-year-old, and a 5-year-old. The dad and the mom were in an accident, and they both passed away, and they left the 3 children without a parent. The father created a will and a trust, and we'll get into what those are, but there are 2 estate planning documents, right? So in his will, the father left his father-in-law, let's call him grandpa, as the personal representative of his estate, the guardian for his children, so that's the person that's going to be taking care of those minor children, and the trustee of the trust, so that's the person that's in charge of the trust. And don't worry about these terms, we'll absolutely get into them. So he funded this trust with their primary residence and a bank account, but unfortunately he left a life insurance policy outside of the trust. And this life insurance policy, he left his 2 sons, the older of the 3 children, as the beneficiaries in equal shares. Now, a minor can't actually receive money, so a guardianship was opened for the benefit of these 3 children, and for the oldest 2, that's where the funds were. So grandpa had an attorney, and that attorney, unfortunately, advised him to add the father's sister as a co-guardian, even though the will didn't say that that's what the father wanted, but this is what the grandfather was advised. So now we have 3 guardianships, and we have grandpa and aunt, and we're just going to call her aunt, as the co-guardians of these 3 guardianships. Well, unfortunately, the attorney for the grandfather failed to handle some very simple yet extremely important administrative issues concerning Social Security money for the 3 children's, but we'll get to that later. So everything was fine. You know, in the beginning, people were mourning, and it was kind of just going through the motions until the family started to fight. And that affected the children a lot because, you know, they've lost their parents, and now we have paternal aunts fighting maternal grandfather. So the 16-year-old turns 18, and his part of the life insurance funds were distributed to him. And then grandpa, thinking he was doing the right thing, tells his grandson, hey, you know, I think you should give 1/3 of your check to your baby sister, because obviously, you know, your dad had that life insurance policy and he took it out before she was born, and it's the right thing to do. It was not the right thing to do, because what happens is when this now 18-year-old gives that 1/3 of his $500,000 check to his baby sister, now that money needs to go into the guardianship, and now accountings need to be prepared for that half of his check. So every year you have to do that accounting, like I said before. Before this deposit was made, there was no money in the account. So the baby sister's account was actually, guardianship was actually a really easy guardianship to manage, but now there is funds. So at the same time that this happened, grandpa and aunt started to fight over the children and the guardianships and how everything was being handled. And unfortunately for both parties, the attorney that grandpa hired was also representing the aunt. So at this point, when these two individuals were at odds, he withdrew from the case because obviously there's a conflict. So he was not allowed to represent them both. So grandpa and aunt hired each their own attorneys, and aunt filed a lawsuit against grandpa accusing him of inappropriately using the 3 children's Social Security funds and failing to account as to how they're being used. So remember in the beginning when I said that the attorney failed to handle some very simple yet really important administrative issues? Well, when a ward receives Social Security funds, the court understands that having to account for each penny is something that's probably going to take more time and cost more money in attorney's fees to create these accountings than the Social Security funds are worth. So at the beginning of a guardianship, if the person only has Social Security, or at least if the Social Security is part of the assets, the attorney for the guardian can actually petition the court to waive the deposit and accounting of those Social Security funds. Unfortunately, the attorney for grandpa and aunt didn't do this and didn't seek permission. So at this point, it had been 7 years since the guardianship opened, and aunt required or filed a motion to compel the grandfather to file an accounting of each of the children's Social Security monies. So that's 7 years of accountings times 2, because we had two guardianships that were open. So that's 14 different years that they had to account for. Luckily, grandpa, I mean, he's one of these old school people that just kept tons of receipts, and thank goodness for him, because he had McDonald's receipts for $5, Burger King receipts for $6, Walgreens. I mean, he had a good amount of documentation, but it was a lot of work, and it cost a lot of money for him to pay his new attorney to create these accountings for 14 years. At the end, the grandpa had to litigate against the aunt and fight for not only control of the assets and to make sure that he got to continue managing these funds for his children, for his grandchildren, but also custody of these 2 children. You know, luckily by this time the children were a little bit older, and the judge took into consideration what their desires were. But there's actually 2 morals to the story. How, you know, and it's not a happy ending, and I apologize, but I promise, you know, it's better to learn from someone else's mistakes and errors than to commit them yourselves. So 2 morals to the story. When you create an estate plan, it's imperative that if you're creating a trust, it is properly funded and that no money is left to any minor children. Otherwise, you're going to have this guardianship issue. And the second lesson is, when you're hiring an estate planning attorney or probate or guardianship, please be picky. Make sure that you ask all the questions. Make sure that you get recommendations, vet them out. If you choose the wrong attorney, it could end up costing you a lot more than you bargained for. So that's pretty much it for that story. And, you know, how is it that we can learn from something like this? And what is it that we can do to avoid it? We create an estate plan. So what is estate planning? Estate planning involves carefully considered and legally documented decisions regarding your estate, your property, your future, the future of your children, and anyone that really may depend on you. And there are 5 little bubbles on the screen because there are 5 different aspects to think of. So let's take it step by step. So the first things that we can ask ourselves are, what kind of decisions can we make? Medical who? Who is it that, if you're incapacitated, that you want to be making medical decisions on your behalf? So you can choose someone that's related to you, or you can choose someone that's not. We'll get into that in a second. Medical what? What kind of treatment do you want? Do you want to be intubated? Do you want to be resuscitated? If you pass away, or when you pass away, do you want to be cremated? Do you want to be buried? Do you want to prohibit an autopsy? If you're pregnant, Do they save the baby or do they save the mother? So all of these things are what kind of decisions can be made. And the third is financial. So who is going to manage your money and your assets in the event that you're incapacitated? So these three decisions are decisions that are made while you're alive, but incapacitated. The next two bubbles are decisions for when you pass away. So the first is testamentary. Who is going to receive my assets? Who is going to control it in a probate estate? And the last is legacy. How will the money be managed for my children, grandchildren, pets? Yes, pets, fur babies count. So don't think that just because you don't have any children that you shouldn't be creating an estate plan for your dogs or cats, or actually had a client that had parrots. So absolutely legacy decisions. So let's talk about the first three bubbles. So the first document that we prepare is a designation of healthcare surrogate. In some states, it's called a healthcare proxy, but in essence, the healthcare surrogate is a document where you name a person or a series of people to make medical decisions for you in the event that you become incapacitated. If you name more than one person at a time, then you're gonna have to decide whether they have to make decisions together. Or if you name people in succession, then it will be the first person that you name, and then if that person is not available or incapacitated themselves or have predeceased you, then the doctors or whoever it is that is relying on this document are gonna go to the second person. So the next document that we have is living will. So the first document controls who makes the decisions. The living will controls what. The living will is instructions, right, for that person that you've named in your healthcare surrogate to be able to say whether you want to donate your organs or whether you do want to be resuscitated. So those instructions are there so that the person that you've named as your healthcare surrogate doesn't have to make the decisions. All they have to do, is follow the instructions that you leave them. And some clients ask me, is it necessary to do a living will? And the answer here in Florida anyway is it's not necessary in order to avoid a guardianship, but it's nice because it takes the burden off of that person that you've named to make medical decisions so that they don't have to sit there and wonder, am I making the right decision? Should I be pulling the plug? Should I keep them alive for 10 years? All of these things can be predetermined by you so that you can, if you're dying, die with dignity and in the terms that you wish. The next document is a power of attorney. This is the document where you name someone to make financial decisions for you. So one of these things that I want to go over is, many clients ask me, what if I created these documents and then I changed my mind? So altogether, let me take it a step back. These are called advanced directives. It's because we're directing in advance what we want with our bodies and with our assets. So they can be modified or revoked as long as you're alive, of course, and you have capacity. Here in Florida, they can be modified or revoked by a written document. So if you create another healthcare surrogate or another power of attorney that can revoke the previous one, you can destroy it. So if you rip it up and it doesn't exist, then those documents are officially revoked, or you pass away. So these documents, these advanced directives, are only valid while you're alive. As soon as you pass away, they are no longer valid. So validity versus effective date. Obviously, I can only advise as to the state of Florida, but I encourage you to seek an attorney to advise you as to maybe the differences in your state as to, the healthcare surrogate and the power of attorney. Here in Florida, the healthcare surrogate is valid the day you sign it, but effective when you're incapacitated. So as an example, if you're in the hospital and let's say I'm in the hospital and they say, Irama, do you want to be intubated? And I say, no, doc, I do not want to be intubated. At that point, the doctor's going to listen to me. But if the doctor says, Irama, do you want to be intubated? And I'm silent because I'm in a coma or I'm just not responsive. At that point, that's when the doctor's going to say, okay, who's your surrogate? Let's get this decision made by that person because obviously Irama is incapacitated. The power of attorney here in Florida is actually a little bit different. It's valid when you sign it and also effective when you sign it. And that was a change in the law in 2011. And they did away with what's known as a springing power. And they called it a springing power because it would spring into effect when you're incapacitated. But as of 2011, it's no longer valid to have that springing power in your power of attorney. So when you sign it, that person that you name to make those decisions for you, known as an agent, can go ahead under that power of attorney and make those decisions for you. So one of the things that I go over in detail with my clients is how to choose the right agent. And it really just starts with trust. You know, you shouldn't be naming someone you don't know. Don't name the president or the Pope. I've actually had that question. But definitely, you know, pick someone that you trust. Pick someone that knows about your finances if you can. Is this person going to do what you ask? Are they going to be able to contact you, you know, if necessary? Do they have appropriate knowledge? You know, maybe they don't manage their own checkbook very well. So you may want to think about, you know, how to choose that right person based on how they manage their own lives. So those are advanced directives. Those are the documents that are created during your lifetime. So the documents that you create, when I say created during your lifetime, I mean for when you're alive but incapacitated. Now let's talk about when you're alive. You have to create these documents for when you pass away. So the first one is the last will and testament. And now if everyone wants to take a sip with me, absolutely you can. So a last will and testament. A last will and testament is a legal document that expresses a person's desires as to how they want their assets distributed when they pass away. It also talks as to who they want to manage those assets. So who the personal representative is going to be, or the administrator, or the executor. You know, if a certain asset is going to go to a certain person, or if it's going to be in percentages. That's what a will does. It does not avoid probate, and we'll get into that. And a trust, usually we prepare revocable trust, is a fiduciary arrangement that allows a third party, known as a trustee, to hold assets on behalf of a beneficiary or beneficiaries. In other words, it's a document that you create with instructions on exactly how the assets should be governed according to the words that you put in this trust while you're alive, and then how they're managed or who they're distributed to when you pass away. So a lot of the times we talk about the similarities and the differences between documents so that we can really get an idea of, you know, which one's right for us. You know, both of these documents have to be signed and witnessed. At least here in the state of Florida, it has to be before 2 witnesses, sometimes before a notary. They both can be modified or revoked. But if the trust is done jointly with a spouse, then both must agree to modify and revoke that. So be careful who you create a trust with. And then when are they effective? So the will, there's a reason it's called the last will and testament, right? So you can create many, many wills in your lifetime. You can create one every day. Obviously that's excessive, and I probably don't recommend it because it'll be very confusing when you pass away, unless you want to confuse people when you pass away. But it's called the last will and testament for a reason. So the will that's effective is the last one. When you die, that's when the will is effective. Obviously, you still have to go through probate. You still have to open up a case. But the trust is actually effective upon execution and funding. So when you sign that document and you put assets inside of the trust, that's when the trust is effective. So will my estate be subject to probate? Will my relatives have to open up a probate case? With a will, yep. With a trust, maybe. And I'll explain why. So which one is right for you? If you are young, a will is a good idea. If you're, you know, just starting out, you know, your family with, you know, it's just you and your significant other, you're in your 20s or 30s, that's all a will is it could be sufficient. If your estate size is not that large, you know, and you're using other transfer methods, and by other transfer methods, I mean, you can have a payable on death beneficiary to your bank account. You can title your property in such a way that it'll avoid probate without having to have a trust. You don't have minor children or pets as beneficiaries. As I explained in the guardianship portion of this, if you have minor children and you leave them assets, any assets, they'll need a guardianship. So it's important to make sure that, you know, if you have children, a will may not be right for you. And if you want to be able to care for your fur babies after you pass, a will may not be able to do that. If you prefer court oversight, I actually once had a mom who was a single mom and didn't really have anybody that she trusted enough to manage her trust for her child. So she said, I can't do a trust because I don't have anybody, you know, and she chose to leave it as a will. But, you know, there are other options. You can choose a corporate trustee. You can choose a bank to manage the funds for your child. But sometimes people just want the court involved, and that's okay. And then last but not least, you have a crystal ball, which obviously a lot of my clients think I do. But if you know exactly what the future will bring in terms of your assets and family, then, you know, a will may be right for you, which obviously is a little funny, but, you know, it is what it is. So a trust. I tend to recommend most of my clients, you know, get a trust, and here are a few reasons why. If the estate size is more substantial, and obviously that's subjective, but I think that, you know, if you have anything worth leaving, then you should do it in the right way. If you have minor children and want to control their funds beyond the age of adulthood, you can do that with a trust. You know, with a guardianship, like that story that I said, the oldest of the 3 children, when he turned 18, that's when he got $500,000. And I don't know about you, but at 18 years old, if I'm getting $500,000, I'm thinking that's more than enough, and I can definitely buy myself my 1969 Corvette Stingray, which may not have been the smartest decision at 18 years old, but I would have been very happy 18-year-old. But with a trust, you can stop an 18-year-old Irama from purchasing a 1969 Corvette Stingray, still on my bucket list, by the way, and make sure that that money is managed correctly beyond the age of adulthood. If you want to bypass probate, as you saw, you know, it's a long process. You have to have an attorney in most, you know, at least here in the state of Florida, in most circumstances, you know, and it could cost quite a bit of money in fees and court costs. And also, one of the things that we talked about was estate litigation. So if beneficiaries are fighting, you know, I think the most common, the 2 most common litigation cases that I'm involved in is siblings who don't get along, whether full blood or half blood. That's definitely one of the top litigation cases. And then I think the most common is when there's a blended marriage, a blended family, excuse me, and then there's a marriage and later in life, and then there's children from a previous marriage who don't get along with the spouse. That one is definitely more common. So sometimes with a trust, you can reduce the risk of that litigation and that kind of exposure. Privacy, that's a big one, at least for me. With a trust, the terms of the trust are private, so no one gets to see what happens. I encourage you to Google celebrities who passed away without a will or a trust, and you get to see all of the assets that celebrity had and all of the drama that's going on in their family. And you know, these things, probate proceedings are public, at least here in the state of Florida. You can just look at the docket. Sometimes you can even read some of the documentation. And with a trust, no one gets to see that, only the trustee and the beneficiaries. So having a trust definitely offers you privacy. And last but certainly not least, our fur babies or feather babies can be well cared for after you pass away. You can set aside a bit of money. You can set aside some rules for caring for your pets. So, you know, that's something that's beneficial for some families. So a trust holds assets like cash, mutual funds, equity shares, bonds, real estate, It can hold all of these assets and control exactly what you want to happen to each of these assets while you're alive and also when you pass away. Now, while you're alive in a revocable trust, you are the main person. So even if you create a trust, don't think that you're going to lose control over the assets because you are the trustee. You are the person that's funding the trust. You're the person that's managing the assets in the trust until, if and when you become incapacitated. At that point, that's when the successor trustee steps into place, and we'll go over the parties in the trust. And then when you pass away, all of these assets that we have here, you have instructions that you customize to meet your own family's needs as to how you want it managed and who you want it to go to. So a trust works by having people assigned to certain roles. So the first role that we have is the settlor or grantor. Depending on the state you're in, those terms are interchangeable, but the grantor or the settlor is the person that's giving to the trust. So if I create a trust for me, I'm the grantor, and then the second person is the beneficiary. Now, while I'm alive, I'm the beneficiary of my own trust. So let's say I'm a single mom, unmarried woman. I create a trust for me. I'm both the grantor and the beneficiary. Then the third term is a trustee. I'm also the trustee. Why? Once the grantor gives the assets to the trust, the grantor no longer controls the assets, and now the trustee controls the assets. I can name another person as trustee, but in my particular case, obviously I want to be able to control all of my assets. So while I'm alive, I am grantor, beneficiary, and trustee. Can there be more than one grantor? Yes. Most of the time, people that are married and that have their assets already jointly create a trust together. So both of them would be grantors, both of them would be beneficiaries, and both of them would be co-trustees. And then they're during the life of the grantor, the beneficiary is the grantor, and then there are provisions in the trust that say exactly who gets what and when while someone's alive. If maybe the first person passes away, and let's say the wife passes away and they want to leave a particular item to their niece upon the death of that person, but maybe not upon the death of both people, you can really customize the trust to say exactly what it is that you want. There's two things that a trust can do, especially when you're leaving a minor child. And when I say minor, it doesn't necessarily have to be under 18 years old. It's under whatever age you feel that child should be receiving the assets. So take me, for example. I have a 4-year-old son who's adorable. I should be putting pictures of him on these slides because he's just so darn cute, but I won't for now. So I have a 4-year-old son. I have no idea if he's going to be financially responsible or if he's going to just want to spend all his money. So in my personal trust, he doesn't get everything until he's 35 years old. And honestly, if I would base it on his actions as a 4-year-old, I may have I may want to extend that until he's like 75, but I also don't want to be an unfair parent, so I chose 35. There's no right or wrong answer. I've had parents choose 40s, 50s, lifetime. Really, it's whatever you feel is best for your assets and your family. So at 35 years old, my son gets 100% of my assets. But before then, he has not access to these funds because he can't write himself a check, but these funds are used for his benefit, and they're used for his benefit in 2 ways. So the first thing that he can do is ask for a distribution. So think of it like an allowance when you've reached a certain age or a certain accomplishment. You can even put in preconditions like education. So for me, education is a really big part of my family, and we believe in higher education. So my kid is going to be able to ask for 25% of whatever's liquid in his trust at 21 years old if he's completed all 4 years of college successfully. I don't care what he majors in, but as long as he completes college, he can get his 25%. But I did put that at 21 years old, which is usually a little bit early than when children, complete their 4 years. But if he does, hey, it's an incentive to get him motivated to complete college early. And if he doesn't finish his bachelor's degree, then he gets nothing. And then he may be mad at me, but at least he'll start, going to school. I do give him another chance, so I'm not that conservative or crazy. But if he does complete college by 23, he gets to ask for that same 25%, and he gets it. Now, one of the things that I do advise my parents with children, sometimes children are not meant for college. And there are many people that I know that have not obtained a college degree, and they're very successful. So I try to keep that in mind, and I try to have, my clients keep that in mind. So for my trust in particular, if he doesn't complete his college education by 23, he'll get 10%. And I figured with 10%, he can start a business, he can invest in real property, he can travel the world, he can spend all of it, but it's not going to really harm him too much because it's only 10%. And then the second way to be able to use the funds are for their benefit. So you can actually put in instructions that say how you want the funds used, and then that trustee that you name, that comes second to you, of course, because you've passed away already, gets to follow these instructions. So for me, I put in that they can be used for his education. So let's say at 18 years old, he says to my first named trustee, I want to go to college and want to study medicine. Okay, that's fine. As long as the trust, let me see, did your mom say that you can study? Yeah, you can go to college. All right. So then the trustee can pay a check to the University of Miami or wherever it is that he's going to get an education. If he needs money for health reasons, medical expenses, all of that can be used. And really, I left it general because of the people that I've chosen to be my trustees, but you can make it as specific or as general as you wish. I've had some people put in money or put in the ability to ask for funds for a marriage, a wedding, cars, travel, purchases of real property, so many things that you can do. It's very customizable to your needs, which is why, if you have a sizable estate, or if you have, beneficiaries that you wish to provide for, a trust is a wonderful idea. So just a little funny tidbit is, how much should a parent leave to their child? And I found this quote to be absolutely adorable, and it's, give them enough to do anything, but not enough to do nothing. Right. So I think that's kind of where I came in, and I said, okay, I'm going to give him 10% at 23, which he can do something with, but, he still has to work, because let's say 100,000 is not enough. Right. So remember in the beginning when I said one of the reasons that people don't do this is because it's complicated or it's lengthy, it takes too long. Well, I'm here to prove you wrong. I have broken this down into 10 steps, and these 10 steps are broken down into 3 categories: before, during, and after. And you're going to see a lot of things in here that don't involve an attorney and that don't involve what you know traditionally to be estate planning. But you do have to start with some estate planning. So the first thing you do is you have to inventory your assets. This is as easy as grabbing a piece of paper and writing down, I have a house, I have the Mona Lisa, I have a Rolex, I have a car, I have a bank account at Bank of America, and you make a list of your assets. If you have any real property, or if you have any stocks or anything, and there's documentation involved with these particular assets, gathering that important documentation. Step 3 is identifying your goals. Sometimes people don't know what their goals should be because they don't know the questions that are going to be asked of them. And something that I offer my clients is this estate planning guide and checklist, and it's about 20 pages long. It's not very daunting, but in there I have these steps listed out, and I do ask those tough questions, like, what do you want to happen with your pets? Whether you want to be resuscitated if you're in a terminal condition. All of these questions and goals are listed in there to help you figure out what's right for you, right? Step 4 is finding the right estate planning attorney. When you're hiring an estate planning attorney, you're creating this relationship that, if it's a good one, could be lifelong. Many times, and something that, you know, I glossed over, but I'm gonna harp on it again, is when you create estate planning documents, you can change them, and you should change them as your life moves forward, as you acquire new assets, or maybe you have grandbabies, or, you know, you move. So if you have an estate planning attorney that you've created a good relationship with, it makes the modification of those documents much easier. You know, starting from scratch is probably going to cost a little more money than if the person who prepared the document can know exactly, you know, what it is that needs to be modified, that knows your family, that can, you know, speak intelligently as to your assets because they're already aware. And in addition to that, you're going to be answering some really personal questions. So you should feel comfortable with that person. You know, I'm going to ask, do you like your children? And your answer may be no. And you have to feel comfortable enough with that person to say, no, I kind of don't like my kids. You know, they're not, one of them is in Texas, the other one is in Canada, and nobody's paying attention to me. So if you don't have that level of comfort with the attorney, you may not be able to give that attorney the information that they need to be able to really draft documents that are going to meet your goals. So during the first thing is, which is our step 5, is answer some tough questions. That goes back to the living will. You know, usually those are the toughest questions. And another tough question that I hate asking, and I think when I became a mom, I realized how difficult this question was. But what if something happens to one of your children? You know, if they pass away, you know, what's going to happen? Do you want that asset to go to someone else? Do you want it to go to a charity like Debbie's Dream? You know, maybe you want to include a charity in your will and trust. You know, those could be some good plans that you can make, but you know, this is usually followed or preceded by some really tough questions. And then is my part, which is to create and to fund the plan. So you're not expected to be a lawyer. You're not expected to know how to draft legal documents. And please, when I say create and fund your plan, I do not mean try to do it yourself. I try to create an analogy, and I use plumbing. And I don't know why. I think I found it so funny. I imagine your pipes burst and there's water everywhere. Unless you're a licensed plumber or have extensive experience with plumbing, I don't see, you know, someone on their hands and knees trying to fix these pipes. You know, it's more like an emergency phone call. Hey, my pipes burst. I need help. It's the same thing. You don't see things from a perspective of an estate planning attorney unless you are an estate planning attorney, and we can see the pitfalls, and we can see where an estate plan can go wrong, and maybe how it's not properly funded. Like in my story, you know, when we had that life insurance policy that was not funded in the name of the trust. So definitely reach out to a professional when you're going to do this, but that professional can create and fund it appropriately. Step 7 is optional, but I do tell my clients to communicate, especially if you're naming someone to make these decisions for you. It's better if it's not a surprise to that person that you've put them in this position, and maybe even get permission from them. When I was choosing the trustees for my child's trust, I reached out to each of I mean, I have like 7 people because, you know, in my field, I feel like everyone's going to pass away. But I reached out to all of these 7 people, and I said, listen, this is what I want to do. I want to put you in line to, you know, manage my son's trust. Is that okay with you? This is what's required. You know, and the same thing with the advanced directives. This is the person that's going to be making medical decisions for you. They should feel comfortable making those decisions. Not everybody feels comfortable making those types of decisions. So for me, communication is actually a pretty important step, but it is optional. Step 8, pre-plan your funeral, burial, cremation, and memorial, if that's something that you want to do. I have personally had to plan a burial and a memorial service, and it was not fun. I would much rather have preferred that she did it ahead of time. So if this is something that, you know, that you can make some time for, please do. I'm sure it doesn't take a lot of time, and it will save your relatives some heartache, some tears, and some headaches. The next step is consider life insurance. I know that life insurance isn't for everybody, but you know, even if it's a small policy, it could really help your loved ones pay for certain things after you pass away. You know, I've had quite a few estates where the beneficiaries had no money to pay the mortgage and the properties ended up in foreclosure. If you have a life insurance policy, you can really help your relatives avoid having to go through that extra step of defending a lawsuit against the estate. And then after, like I said before, is update your plan regularly. Now I have to drink some wine. I've been talking for way too long. And hopefully not boring anybody. But update your plan regularly. Like I said before, you know, if you have a change in assets, if you have a change in family, you know, so if anything with you changes, if you have a change of heart, you know, sometimes we name certain people in our documents that were around and they were good while they were there, but they're no longer, you know, part of our lives anymore. You should be changing your documents. If you get divorced, that's a really good time to change the documents. I don't think, you know, you want to have your ex-spouse making decisions for you. They may pull the plug and you didn't want that. So definitely take a look at your plan. I always advise my clients to take a look at their estate plan every 3 years, but that's definitely something that you need to do. I look forward to, you know, connecting with all of you. These are my social media. If, you know, you want to follow me, if you want to ask me questions, you know, if you want a particular blog entry about a subject that you're interested in, I'm happy to do it. At this time, I would love to invite Jackie back. If there's any questions that I can answer, I'd be happy to. I can't hear you.
There you go. Thank you so much for sharing with us today. We received some questions during your presentation. The first one is, what if I have a healthcare surrogate the hospital gives me only? What's the next steps?
Well, the healthcare surrogate at the hospital may be okay. Obviously, I tell my clients, you know, send it to me, let me review it, let me see if it's still what you want. But the healthcare surrogate is not enough. Obviously, that's only for medical decisions, and then we're missing that financial decision. So if you only have a healthcare surrogate, you may want to consider creating a power of attorney if that healthcare surrogate is good. And obviously, that's only during your lifetime. So you need to also consider a will and other testamentary documents.
Next question. What if I just do a will? Will my kids still need to hire an attorney?
So yes, like I said before, a will does not avoid probate. The will it may be valid, but it's not effective until the court says so. So when we start a probate estate, we actually have to ask the court to admit the will. And then once the court admits the will, that's when we can start, you know, the process of bringing in the assets and distributing them to the right person. So it is not an easy process. Many, at least here in Florida, many counties don't allow individuals to do this process by themselves. And here in Florida, we have a rule that says you have to have an attorney. There's a few exceptions if you're the only beneficiary, I think, and maybe if you're the spouse and there are no other children. But even still, I always recommend obtaining an attorney.
Okay. Next question. If I prepare a trust, do I have to continue using the services of an attorney?
That's a really good question, and one that I'm asked often. So the answer is probably not. The trust is made so that you can manage it on your own. And when I prepare a trust for my clients, I give them kind of like an instruction book where it says, okay, if you're going to buy property, this is how it's titled. Don't put cars in there. If you have a CD, this is how the CD should be titled. If you're going to have a life insurance policy, this is how the beneficiary should be titled, so that, you know, that person can really be independent and not be dependent on the services of an attorney. The attorney should be there to guide them. So I also offer that to my clients, and if they have any questions, I'm always available to answer. But really, it can be managed without an attorney unless you name an attorney to be your trustee. In that case, obviously, then you have your attorney managing it.
Mm-hmm. Okay, next question. What if I created a power of attorney and now I don't want them to be my agent?
So in that case, if when you don't want them to be your agent, you have capacity, you can revoke that power of attorney. And you can do it one of two ways. You can either create a new power of attorney that specifically or generally revokes the previous power of attorney, or you can create a revocation of power of attorney. That's a very simple document that says, I created a power of attorney on such and such date, I no longer want it, I revoke it, and then that gets filed with the county here, at least in Miami-Dade, and it acts to revoke it.
Okay. Next question. Can these documents be signed and witnessed electronically since we have COVID going on, and a lot of our patients are immunocompromised?
So it depends. And I hate to give you that lawyer answer, but it depends. So I know that this isn't just being aired in Florida, and we have people from all over, but here in Florida, and I urge you to speak with an attorney, make sure that you get the law that's appropriate in your area. But here in Florida, we do have a law that allows the electronic execution and witnessing and notarization of testamentary documents. And that includes the power of attorney, the healthcare surrogate, but with a big but, a big caveat is that if you are a vulnerable adult, you cannot do this electronically. So the statute does have a definition as to what a vulnerable adult is, but it's pretty general. It's someone who's over the age of 18 that needs assistance with their ADLs, so activities of daily living. And how to determine that, it is a fine line that I have to walk. But it's something that if it's unclear whether it's someone that's a vulnerable adult, I'm not going to put them on in that position, because I don't want to risk their true intentions not being complied with. So if it's someone that is immunocompromised, there are ways of getting these documents signed in a safe manner. In my firm, we've been doing it through a window, and with gloves and masks and antibacterial at all times. But we have been able to do that, and as long as the witnesses can see the person signing, can hear the person, and that can be at a distance, that can be done. So I've had quite a few elderly people that have wanted some estate planning, and we've just done it through a window. But we have had some electronic signatures for people that are not vulnerable adults.
Okay, next question. My husband is incapacitated. Can I still get a POA for him?
Can you still what?
Get a power of attorney for him.
Okay, so no. So to be able to execute a power of attorney or a healthcare surrogate or any of these documents that we're talking about, you have to have capacity. You can't create a power of attorney for someone else to be able to take care of them. If it's gotten to that point where they are incapacitated and you're looking to make decisions for them, that's when the guardianship or conservatorship comes in.
All right, last question. I have a property. Can't I just do a will and not anything else?
So if you have a property and you create a will, the answer is the same. You're going to have to go through probate. But there are different things that you can do to avoid probate and maybe not necessarily create a trust. You can retitle the property. Either you can put someone together with you, and there are pros and cons to that. If you put someone else on the property, that also becomes their property. So if at any time your relationship suffers and they want out and they want their half, they can actually file a lawsuit against you. So that may not be the right thing, or maybe it is. You never know. I always give my, I always compare estate planning to a road trip. And I always pick New York. I don't know why, maybe because I drove there once. But, there's no one right way to get to New York. There are different expressways, and you can go through the mountains or you can go through the coast. Estate planning is the same way. There are different ways to meet your goals. It's just, what is it that you're willing to compromise? What is it that you're willing to give up? What is it that you want? Maybe, we have 3 options, but only option C covers all of your bases. So.
All right, well, unfortunately, we're out of time. Thank you so much for joining us today and sharing your expertise.
For having me.
Of course. If you'd like to connect with Irama or her team, Please see their contact information here, or you can visit their website at probatelawmiami.com.
And cheers to everybody.
Cheers,
Thank you.
everyone.